My name is Dennis Shaffer. I am a partner in the Bankruptcy and Restructuring Group with Whiteford, Taylor, and Preston. Thank you for joining me for this webinar today. I've been helping clients navigate insolvency and restructuring related matters for over 20 years. And what I'd like to speak with you about today are some benefits that small businesses may get from the recently enacted Small Business Reorganization Act, as well as a significant change that recently occurred under the CARES Act, which was enacted in response to the COVID-19 pandemic. Generally speaking, businesses are eligible to file bankruptcy under numerous sections of the Bankruptcy Code. Chapters 7 or 11 are the typical chapters in which a business would file. Chapter 7 is mainly for liquidating a business, and Chapter 11 can be used for either liquidation purposes or for reorganization. To reorganize, Chapter 11 is a very good tool for many businesses because it has several key features that would allow a business to reorganize its debt and hopefully come out the other end as a restructured entity that will be able to continue operating. One of these key features is that a business can remain operating as normal in a Chapter 11. Current management can remain in place. And the basic purpose of filing Chapter 11 is to allow the business to negotiate a plan to pay its creditors over a period of time moving forward. Another key benefit that many businesses really need is that once a bankruptcy file is filed, there's an automatic stay that stays all of the pending collection action and related litigation activities for an indefinite period of time. And this allows a business to get some breathing room as it walks into a bankruptcy case. Now I'm going to switch to something a little bit more specific and talk about small businesses and how they can reorganize in Chapter 11. In 2005, there were some key amendments to the Bankruptcy Code, some of which were designed to help small businesses utilize Chapter 11 a little bit more easily to reorganize. This allowed for a more streamlined process. However, one big downfall is that it still remained very expensive for a small business to actually reorganize through Chapter 11, and I will touch on this in a little bit more later on in the presentation when I discuss the Small Business Reorganization Act and its provisions that are much more helpful in this regard. The other factor that was a little bit difficult for allowing small businesses to really take advantage of Chapter 11 is that all creditors would still have to be paid in full for an existing equity holder to keep its ownership interest, or equity holders would have to put in more capital to keep their ownership interest in a typical Chapter 11 case. The Small Business Reorganization Act that was recently enacted in February of 2020 is truly a game changer for small businesses. It is voluntary for businesses to file under this new subchapter. The subchapter has many advantages over the pre-existing law, and it is much easier and quicker to work through a reorganization under this subchapter of Chapter 11. So how does a business qualify? In order to be able to take advantage, business must have total non-contingent liquidated debts under approximately $2.725 million. And what that means is that if there's a significant piece of litigation over a debt that is disputed, that would not be counted for this cap purposes. So if an entity is being sued for $5 million, but really thinks that it owes $100,000, you would count the 100,000, not the 5 million, in terms of being qualified under the cap. Another qualification is that 50% of the total debt has to be from business activities. And this is because individuals can also file Chapter 11, and they can also file Chapter 11 under the Small Business Reorganization Act. An example would be a sole proprietorship, family business, things of that nature. One other qualification that is key is that a single asset real estate entity cannot be a debtor under the Small Business Reorganization Act. And an example of that is a limited liability company that may own one apartment building where the key asset is really only one single piece of real estate. Now, the benefits under filing under the Small Business Reorganization Act are significant. There are significant cost savings over a typical Chapter 11. The process is much quicker, much more streamlined, and it is very much easier for equity holders, the owners of the company, to maintain their equity interest, even if they cannot get not all creditors, but any creditor to agree with a reorganization plan under certain circumstances. And I'll walk through that very shortly. With respect to cost savings, there is no what's known as a creditors committee. In a typical Chapter 11, the United States Trustee's Office has the ability and often does appoint a committee of unsecured creditors to oversee the unsecured creditors' interests in the bankruptcy case. These committees, which are statutory in nature, can hire their own counsel and their own financial advisors, and the debtor, the entity that actually filed bankruptcy, has to pay the costs and expenses of the committee's professionals. This can be very expensive in a Chapter 11 case because you're paying for, the debtor is not only paying for its own professionals, but is also paying for the committee's professionals as well. But under the Small Business Reorganization Act, there is no committee unless the judge orders it, and this is a very significant cost savings. Another cost savings is that there are no United States trustee fees. There are quarterly fees that are due to the United States trustee for debtors who have filed under Chapter 11. They start at about $325 and can go up to over 1% of any amount that is dispersed in a typical quarter of $1 million. So as you can see in the slide here, it could be very expensive if the debtor disperses $300,000 in a quarter. The U.S. trustee fees for that quarter is almost $5,000. And this can really be compounded if you have 2 or 3 smaller entities that are related that have to file bankruptcy together. Each entity in bankruptcy will get this bill. Under the Small Business Reorganization Act, however, these fees do not have to be paid. It's another tremendous cost savings under this new act. Additionally, the costs for legal counsel will be significantly less because there are fewer filing requirements. Your plan of reorganization is not as complex as a plan in a typical Chapter 11 case. There are a lot of forms that are being put into place as suggested forms by the U.S. Trustee's Office as well as on the court's website that are much easier to fill out and will cut down on legal fees in preparing those forms. And there's no requirement for a separate, what is known as a disclosure statement, which is basically providing information about the entity that's in bankruptcy and the reasons why the company went into bankruptcy and how it's going to move forward. A lot of those provisions have been trimmed down and will just be included in a plan in a Small Business Reorganization Act case. Some of the other beneficial aspects of proceeding under this subchapter of Chapter 11 is that it's quicker. A reorganization plan has to be filed within 90 days of filing bankruptcy. You'll have to go to an initial status conference with the court within 60 days of filing, and you have to provide an initial status report 14 days before that initial status conference. But what the purpose is here is that it forces the debtor to begin the reorganization process very early on in the bankruptcy case, if not before. Also, during this time, once the case is filed, there will be a trustee appointed from the U.S. Trustee's Office that is not taking over the business, but is there to help the debtor work with its creditors in trying to negotiate a reorganization plan. And as I mentioned earlier, it's easier under this subchapter for equity holders to maintain their equity interests. There are 2 ways to do it. One would be a consensual plan of reorganization where the creditors agree with the repayment plan that is proposed by the debtor, and the other is what's known as a cram down or non-consensual plan. And this would be used if all creditors don't agree with the repayment proposal offered by the debtor. For the non-consensual cram down plan, there are a couple of requirements. It has to be fair and equitable, and what that means for unsecured creditors, and these will be the parties that a business owes, typically trade debt, things of that nature, creditors that don't have any collateral. For these parties, fair and equitable means that the debtor is going to use its projected disposable income over a 3 to 5 year period moving forward to pay these creditors. Now, that's a little different than some other ways in which a debtor could pay its creditors in a Chapter 11 case, which would be, a specific certain percentage. This would be simply whatever the extra money that the debtor has over that time period, it would go to pay down the debt, regardless of what it is. For secured creditors, that fair and equitable requirement means something different, and I'll get to that in a minute. With respect to the disposable income requirement, what's meant by that is that it's all business income that's not necessary for maintenance or support obligations of the dependent or of the debtor or the debtor's dependents, and that would really come into play if it were a sole proprietorship business. Domestic support obligations are similar, and general required business expenses. With respect to secured creditors, it's different. Secured creditors will be treated very much the way they would in a typical Chapter 11 case, and that is that they're maintaining the status quo. So they'll either retain their liens and receive cash totaling at least the value of what their collateral is moving forward, or the liens themselves would attach to any sale proceeds if their collateral is sold, or they'll get something that is what's known as an indubitable equivalent of what their claim would be in the bankruptcy case. And that could be payment over time, similar to the payments that would be made to an unsecured creditor out of the disposable income. A couple of other points to consider. Individuals, as I mentioned before, can file Chapter 11, and they can also elect to proceed under the Small Business Reorganization Act. If an individual does file and has used mortgage proceeds on their primary residence for business purposes, that debt can be modified under the Small Business Reorganization Act, which is different than a typical Chapter 11 case. But one requirement is that those funds that were borrowed had to have been used for business purposes. I mentioned earlier that there were some cost savings. There is a trustee that will be in place to help the debtor work with its creditors. That is a cost that the debtor would have to pay. At this point, it's really unknown because the law is so new as to how exactly that will work and how much that would cost. But through my years of experience, I would expect that the cost of a trustee under Subchapter 5, the Small Business Reorganization Act, would be significantly less than the U.S. trustee fees are paying for a committee's professionals in a case. A couple of other issues. One big advantage, why would a party, an entity file bankruptcy? To get a discharge of their debt. So what would happen is an entity will pay a certain amount over time, and the remaining debt after those plan payments are made would be discharged. In a Subchapter 5 case, under the Small Business Reorganization Act, if the plan is consensual between the debtor and the creditors, then that discharge of debt would occur as soon as the plan is confirmed, and that would be before any payments were made under the plan. However, if the plan is not consensual, you didn't have agreement of your creditors, but you were able to cram down the plan anyway because you're complying with the requirements of paying your disposable income over time, well, that discharge won't happen until you make distribution payments for at least 3 years. Now, in conclusion, I wanted to point out one significant issue with respect to the recent CARES Act that was enacted into law in March of 2020 to deal with the pandemic, and that is that the debt limit for taking advantage and filing under the Small Business Reorganization Act has been lifted to $7.5 million for the year following the date the act was put into law. That's very significant. It almost triples the debt cap that an entity or an individual would have to comply with in order to take advantage of this new law, which is a tremendous opportunity to reorganize a business and restructure without having to sell it or lose your equity interests. So the $7.5 million will open up for a lot more businesses the opportunity to take advantage of this law. With that, I will conclude and thank you for your time and listening to the presentation today. If anyone has any questions about reorganization or restructuring debt, whether in or out of a bankruptcy, and in particular with respect to Chapter 11 or anything that was covered under the presentation today, please don't hesitate to contact me. My email is dshaffer@wtplaw.com, and my direct phone line is 410-347-9437. Thank you again.